Welcome everybody to this cover talk session dealing with medical malpractice claims and particularly policy issues that can arise during the course of a claim. I'm joined today by Wanda Karow, a Principal Associate, and Amy Bell, an Associate in the team who deal with medical malpractice claims. Just a few points of housekeeping. This session is being recorded, and whilst you can see us, we can't see you. The recording will be available afterwards if you want to recap anything or indeed share it with anybody. We won't be finishing today with the traditional Q&A session because we are following a case study, but we are always interested to hear any comments and of course to answer any questions that you have. So please do feel free to put anything in the chat box function with your name and email address, and we'll make sure to come back to you after the session. Alternatively, you can always contact us directly. So on to today's agenda. As I say, we're going to be looking at a case study of a medical negligence claim. We won't be considering the more traditional issues of breach, liability, causation, loss. Instead, we're going to show you what policy issues can arise during the course of a claim and how that can impact on settlement. We hope by the end of today to have answered the question whether or not a straightforward claim is ever really that straightforward, although I'm sure I'm not giving the game away to explain to you now that the answer is almost certainly going to be no. So without further ado, I'll pass you over to Amy, who will introduce the perhaps soon to be infamous Mrs. Bloggs.
Thanks, Sarah. So before I recap and go over the background, just a quick disclaimer that this is of course a fictional account, although all of the issues that we mention have arisen at some point during cases we've dealt with at Mills and Reed. Although admittedly, they're not all usually in the same claim together. So as Sarah said, our case study is the imaginatively named Jane Bloggs. Jane Bloggs has recurring knee pain that's been getting worse over the past few years. She's known to suffer from osteoarthritis of the knee, and in January 2018 goes to see Mrs. Fixit, a consultant orthopaedic surgeon at Dean Hospital, her local private hospital. After discussion, they agree that she should undergo a total knee replacement and she's booked in for surgery. The surgery appears to go to plan, but no post-operative imagery is taken. Mrs. Fixit directs that Jane Bloggs undergo a 6-week period of intense physiotherapy. She is scheduled to see Mr. Motivator, who couldn't be anything other than a physiotherapist with that name, and he sees her on a private basis at Dean Hospital. During her early sessions, Mr. Motivator, Jane Bloggs explains that she's having severe pain around the joint, and it seems in excess of the recovery suggested by Mrs. Fixit. She asks Mr. Motivator if she should go back to see the surgeon earlier than planned, but Mr. Motivator thinks Jane Bloggs is a bit of an exaggerator and ignores her request. By week 6, she's still suffering with instability and bouts of severe pain, and decides to book herself back in to see Mrs. Fixit. Mrs. Fixit is concerned about the level of pain being suffered and orders an imaging of the knee. On review, it is identified that a fragment of the prosthesis appears to have broken off. Revision surgery is booked in, but as Jane Bloggs no longer has private health insurance, the surgery is undertaken on the NHS. Unfortunately for Jane Bloggs, Mr. Oops is the theatre nurse on shift, who accidentally drops a used swab into the surgical site. The offending item is removed immediately, but its presence means that Jane Bloggs has to have an extended course of strong antibiotics, which leave her drowsy and unable to work. Finally, by August 2021, Jane Bloggs is able to walk unassisted without pain, 2 years later than the original estimate provided by Mrs. Fixit. She is understandably traumatised by the whole experience and makes a complaint to the GMC about Mrs. Fixit. She also goes to see claims and co-solicitors who advise her to bring a claim in relation to the extended period of pain and suffering she has endured. But given all of the issues she has faced, the question is, who will she claim against?
Well, I think that's fairly straightforward for claims and co. Mrs. Fixit, she did the operation, she inserted the prosthesis, her insurer should pick this one up.
But was it all Mrs. Fixit's fault, Sarah? Remember the theatre nurse? She dropped the swab in the revision surgery, and Mr. Motivator, obviously he's added to the delay.
Okay, so it's still one claim, but we've got 3 potential defendants, which should mean 3 insurers picking up the tab?
Not necessarily. Remember, Sarah, that there's two operations here. The original one caused the issues due to the prosthesis, but that's entirely unconnected to the swab incident with the theatre nurse during the revision surgery. Now, Mrs. Fixit is the common denominator, but remember there's two hospitals, one HS and one private, and the policy will undoubtedly exclude NHS work.
Yeah, and sorry to jump in here, Wanda, but are we actually sure that the hospital would be responsible for Mr. Reeves, whether on the private basis or on the NHS? Could he not, for example, be employed by an agency?
That's a good point, Amy, actually, because that often does come up in practice. Certain shifts are often covered in a variety of hospitals by different agency nurses. And here, what you'd have to look at is the arrangement with the agency. Now, the nurse is often required when engaged by the agency to provide evidence of their own indemnity insurance, and the agency should be keeping these details on file.
And if Mr. Oops has lived up to his name and not done that, Wanda, what would be the issue?
Well, I mean, that does happen, and we have seen that, or it happens that the agency hasn't kept a record and the nurse can't be located. And there the agency has left themselves potentially in the frame under issues of non-delegable duty and vicarious liability, which is an area of the law which has been moving fast in recent years.
Okay, so for Claims and Co, their one claim is still one claim, but it covers 2 periods. It has 3, possibly more defendants, and so 3 possibly more insurers. It's getting a bit more complicated for them, but I'm sure they'll power through.
Not so fast, Sarah. What about that prosthesis? Didn't that break in the original operation? You need to consider whether that is Mrs. Fixit's fault, or was the prosthesis faulty, in which case you might be looking at a product manufacturing issue, which is almost certainly going to be excluded.
And what happens then? Would it be a new claim?
Well, the patient should then report the incident, but she would have to prove that the product is inherently defective. I mean, products do fail, but not always defective. And it could just be one of those things, or it could be down to Mrs. Fixit and surgeon error as to how that's being used and implemented. However, here we think the product is defective.
Okay, so Claims and Co's workload is getting a bit heavier. They've now got potentially 2 claims if they go on the product manufacturing route. But in terms of the original claim we were looking at, they've now got 1 claim, 2 defendants, 2 periods, 4 potential defendants, policy exclusions. There's quite a lot going on here for them.
Yes, and don't forget, Sarah, you've got that GMC investigation, fitness to practice investigation, and you can't bar that out in any settlement.
But surely from a policy perspective, that GMC investigation is covered.
Well, we'd usually see it covered under a separate legal expenses policy, but you would need to check, as every policy is, of course, different. And remember, again, there's issues between the NHS and the private work.
All right, blimey, that's really not looking as simple as it first looked, is it? But to their credit, Claims and Co power through and continue pursuing the claim. Notes reveal that during a complaint meeting initiated by the hospital, Mrs. Fixit apologised to Jane Bloggs for the additional distress that she experienced, but she maintained that there was absolutely nothing wrong with her operating technique.
Oh, Mrs. Fixit, has she gone and thrown us another policy issue to consider?
Well, Sarah, it's often a condition of cover, as you know, that an insured mustn't admit liability without insurer's prior consent. But here, no, we don't think there is any issue, because if the apology is worded correctly, then that should be fine. Of course, a surgeon does, of course, owe a duty of candour to the patient. Also worth remembering here that if the surgeon does refund the fees, they're not covered under the policy and would not therefore be payable by insurers.
Okay, so it looks like Mrs. Fixit managed to dodge a coverage bullet there. And even better for her, the GMC conclude that there were no fitness to practice issues, so that element of the claim resolves. The civil claim continues, and given the number of issues, a roundtable meeting is arranged at the hospital to discuss resolution. Jane Bloggs is accompanied by her husband Jim, And on the way into hospital, what do you know? Jim trips over a loose paving stone and breaks his ankle.
This is a very unlucky family, but surely for Jim, he's okay. The only reason he's there is because of this claim, and so Mrs. Fixit's insurers will deal with any costs that he has as a result of his broken ankle.
Well, another claim for Claims & Co here, because that wouldn't be covered under that policy. It would be under the hospital's policy, EL and PL policy.
So Claims & Co really have got a lot of work on their plate at the moment, don't they? So in summary, what initially seemed like a relatively straightforward clinical negligence claim really rarely ever is that straightforward. Although we do have to admit that perhaps not all claimants are as unlucky as Jane blogs.
So hopefully that whistle-stop tour through a fairly embellished case summary has shown you the number of policy issues that can arise during the lifetime of a claim. To recap, we've seen the NHS and private distinction for policy, which arises on multiple claims and can often occur where the same clinician sees patients in an NHS and a private setting for the same course of treatment. We had agency issues with Mr. Roops and the need to make sure that any potential additional insurers are brought in that respect. We had, as ever, policy exclusions, and it's really worth bearing in mind on the exclusions front that whilst each policy will have standard wording, there is very often unique exclusions for individual clinicians. And so you cannot just assume that the exclusions will or will not apply. We had regulatory issues which brought up the issue of legal expenses cover and potentially the need to notify other insurers on that front. And of course, the raft of other policies that the hospital might hold, which would deal with things like Mr. Proggs's slip and trip. So how does this all factor into settlement agreements? Well, whenever you're negotiating a multi-party settlement agreement, and particularly those that have full and final clauses and look for indemnities to be given or offered, you need to bear in mind all of your potential defendants to ensure that there's nobody that might come out of the woodwork, and also to ensure that as the insurer, you're not overpaying for an element of the claim that shouldn't rightly fall to your cover. For each potential defendant, you need to consider the location and employment arrangements of them. You need to look at any product or third-party involvement issues that could arise. There are always regulatory concerns which could trigger separate insurance cover. There's the duty of candour, which quite often jumps out and appears to be a policy issue, but if worded correctly, as Wanda said earlier, shouldn't cause any difficulty. And of course, policy exclusions. Now, today we haven't even looked at what happens before the matter gets to the claim and the notification, but that was dealt with by my colleagues Claire and Matthew in their previous cover talk session, and that's available on the website if you'd like to revisit. So all that leads me to say today is thank you very much for joining us, and we hope you'll have a lovely rest of the day.